Ready? Exercise number 22, Series B, Legal Matter, start. These special leave petitions are against a common order dated 5th March 2021, passed by a division bench of Calcutta High Court, in two writ petitions filed as public interest litigation under bracket PIL bracket out, being WPA under bracket P bracket out number 68 of 2021, under bracket Nilanjan Adhikari versus the State of West Bengal and others bracket out. Order dated 10th February 2020, passed by the Additional Chief Judicial Magistrate, discharging the petitioner from criminal case number 368 of 2007 and other similar orders passed on divorce dates, discharging various persons accused from criminal cases against them, have been stayed, and the concerned courts have been directed to take note of the orders of stay and to deal with the criminal cases accordingly. Stop. Next para. Learned counsel appearing on behalf of the petitioner has argued that even though the persons who had been discharged from the criminal cases were directed to be impleaded in the writ petition and orders of discharge impugned in the writ petition were stayed without hearing the discharged persons, including the petitioner herein. Learned counsel appearing on behalf of the petitioner as also counsel appearing on behalf of the state submitted that the public interest litigations were initiated by persons belonging to a political party for oblique reasons. The public interest litigations should not therefore have been entertained. Stop. Next para. While it is true that the court is required to examine whether a litigation is really in public interest or to advance some other interest in the garb of public interest, at the same time, a public interest litigation cannot be thrown out only because the petitioner belongs to a rival political party. Persons with political affiliations are as much entitled to file a public interest litigation as any other person. Whether the litigation is bona fide or not is a different issue which has to be examined by the court on a case-to-case basis, having regard to the nature of the complaint before it. Stop. Next para. We may add it shall be the duty of public prosecutor to inform the court, and it shall be the duty of the court to appraise itself of the reasons which prompt the public prosecutor to withdraw from the prosecution. The court has a responsibility and a stake in the administration of criminal justice, and so has the public prosecutor. Its Minister of Justice both have a duty to protect the administration of criminal justice against possible abuse or misuse by the executive by resort to the provisions of Section 361 of the Criminal Procedure Code. The independence of the judiciary requires that once the case has travelled to the court and its officers alone must have control over the case and decide what is to be done in each case. Stop. Next para. If ill-informed but well-meaning bureaucrats choose to use expressions like the public prosecutor is directed or the public prosecutor is instructed, the court will not on that ground alone stultify the larger issue of public policy by refusing its consent on the ground that the public prosecutor did not act as a free agent when he sought withdrawal from the prosecution. What is at stake is not the language of the letter or the prestige of the public prosecutor, but a wider question of policy. Full stop. Thank you very much.